accused is represented by Mr. Mashambu. Matter is on the road for further investigation. The investigations are complete. State request a remand. Your worship, the accused is facing another similar charge, and state is of the view that matters have to be centralized to be tried at the same time in the High Court. So therefore, state will request a remand for DPP decision and possible centralization.
Good morning. The submissions by the state and the court report will indicate that in the last occasion, the same song and dance was made about the centralization of these matters. The same song and dance was made about the DPP's decision to have these matters centralized. The same song and dance was made about the accused before facing multiple charges. These multiple charges are charged with remand in the Human Magistrates Court. The last occasion when the state appeared, they made a submission to the court to the effect that they were intent on centralizing these matters. And the purpose of that postponement was there for them to activate the intention that they were going to centralize the matters. Now, Your Worship, I hear that they claim that their investigations are complete. I do not know in which sense the investigations are complete. They say that the matter is to be transferred to the High Court. I do not know whether they arrange dates with the registrar. I do not know what arrangements exist as between the state and the registrar of the High Court in the first division. And when they say the investigations are complete, what is it that they are referring to? Does it mean therefore that their matter is trial ready? If we were to start trial tomorrow, they'll be able to continue tomorrow. Or there'll be another song and dance about one or the other thing. Now, insofar as the human matter is concerned, the state with the previous public prosecutor had said that the ball is rolling. The processes are afoot that the matters will be centralized, meaning the cases will be transferred to the current one. I was expecting the minimum that today the matters will be joined at least, but when they are being transferred to the High Court, we transfer them as one matter. These conversations will be the same. Now, if the state then wants to come and say to us that they're making the self-same request, that the investigations are completed, that the transfer, they intend to join the matters. What they're saying in essence is that they still have to go and try and centralize these matters. You must remember, centralization is not a given. It's not a given. There should be reasons why they're centralizing this. We cannot just say simply because there's one accused similar offenses, therefore the humanitarian centralization does not work that way. Different jurisdiction, you have to deal with various other issues. Now, they are saying the DPP's decision as if they themselves have to go and apply somewhere to somewhere, whereas they are the DPP. They are the ones who make the decision. So when they are saying that they are asking for DPP's decision, which other DPP are they referring to? Because they have to make that decision. The report will indicate again that the prosecutor who dealt with the bail application was the supervising prosecutor. He's the decision maker. He's the one who decides who goes where and how and where. Now, these people are sitting 2 offices away from one another. Yet we are being told that it's as if the district court prosecutor requesting the DPP's intervention. You're speaking about people who hold meetings almost on on a weekly basis to discuss these issues. We were told that this is a sensitive matter, this is a high-profile matter, but the state is behaving like this is any other matter. There's nothing high-profile about their conduct in them prosecuting this matter. They've actually taken all necessary steps to ensure that they frustrate the accused. I do not want to beat an old drum to try and make a new song from that meeting. But when they opposed bail, they told us that she was facing a very serious charge in Zimbabwe, and the bail was refused on that basis. I've been to Zimbabwe Ministry Court more than 4 times. I can say without any hesitation now that those charges have been withdrawn in Zimbabwe. Contrary to what the investigating officers ETL said to the court, I can say that without any measure of contradiction, that the investigating officer in that matter, and I'm saying this is an officer of this court, and the record in Zimbabwe Ministry Court will indicate as such that the record of the Ministry Court in Zimbabwe will indicate as such. So what is sitting with here now is the attempt by the state to render this court complicit in their conduct to prolong the frustration of the accused persons. Now, in the minimum, what they ought to have said to this court is that our previous submission with regard to the transfer and the joining of these matters is at this stage. Minimum. To take this court into confidence and say, we are at this stage. Now, if they say they want to join these matters and they say they have completed their investigation, it means this matter is not tried by any stretch of the imagination. What does that mean then for the accused before you? What it means in simpler terms and in simple language, and not to insinuate anything against the conduct of my learned colleague here, saying that he's the newest prosecutor in this matter. They are trying to circumvent the Chief Justice's directives in relation to the 6-month period. They are quite aware of that 6-month period. They know that if they do not comply with that 6-month period, this honorable court is going to hold them to account. Now they come to court and they say their investigation is incomplete, or they are complete, and they want to go, they're not saying that the matter should be transferred, they're just saying that the matter is incomplete, but they intend to join these matters. What that means in essence is that even if the investigations are completed, the fact of the matter remains that they would not have complied with the 6-month period. Their matter is not trial ready. We're still sitting with a case in remand that is needing to join the case in African. They do not say to you whether they've started the application to join these matters. They do not say to you whether how far, if those processes are underway, how far they are in relation to them being trial ready for this matter. Hence I said in my initial submission that if this matter were to go, if we were to say now, tomorrow, let's go to trial, the state would be flannered. The state would not be able to stand up and say that they are going to prosecute. So the attempt for them to come today and make a submission that the investigations are complete, it's an attempt to circumvent what the Chief Justice's directives say in relation to a speedy and fair trial. That is my 50 cents worth. I know I'm long-winded in my submissions, however, I should make this point and get this point home. That the state is being unnecessary. The state is being deliberate in their conduct. The state is not playing open cards with this court. And the court ought to put very specific questions to the prosecutor to answer to in relation to their state of readiness, in relation to the joining of the charges and the joining of the cases in Human and this case in African. The investigation in those investigations in that matter, seeing that we are working with one investigating officer, are investigating in that matter completed as well because they intend to join these matters. So it means that all the investigations in relation to both cases they must be completed. Because I do not want to go to the High Court and get told that we're still waiting for a statement from person X. We're still waiting for this from the person. Yes, they're shifting the forum, then they're going to be forum shopping in the High Court and make submissions in the High Court that they can initially make to this court, which would then necessitate that the defense has to come back to this court, pick up the charge sheet here, and serve it with it, and go and present it to the High Court in Mafeking. I would rather that when we leave this court, we are clear on what is going to happen in the High Court in Mafeking. I don't want to be getting and start then looking at this, and I don't want to get and start waiting for this stuff. Witness to submit a statement. They need to say that they have all the necessary reports, all the necessary medical reports. They need to say that they have all their witnesses ready, their witnesses statements, everything is above board. They need to say that there is nothing outstanding. That if we were to request a specific document, they will be able to provide that document without hesitation. As God please the solution. Unless there's anything the court wants to hear from me, that would be our application. At least the state is really playing legalities. The state is controlling their conduct. They know for the fact that the investigations are not. They know for the fact that the state is struggling. They are going to struggle to join the two matters. Because they have not even started with the process of joining the two matters. Now, why do you say that you are ready to go somewhere else? Why do you say that your investigations are completed? You're saying that investigations are completed, but if it was time now, you're going to refer us to the case in Human, you're going to refer us to the fact that you still need to join these two cases. I mean, there's been this song, I mean, we were told about this thing in March, February already, that there's a case in Human, they will intend to prefer against that accused person, then they will intend to join the two charges together, but today you're still getting the same submissions that they intend to join these two matters. What is preventing them from joining these two matters? What is it that is a hindrance to the DPP? Now we've been told that they're waiting for the DPP's decision. Who's the DPP? Because the prosecutors sitting here, when the local prosecutors, the district prosecutors send documents for decision, they send them to my colleague sitting here today. He is the DPP. So which DPP are they referring to? Because this matter resides with them and not with the in-house prosecutor. And I request that this court must ask this specific questions to the state. The state must provide the information, because we cannot be sitting here and playing games that are informed by everything else except what we are here for. I'm here to try this matter. I'm ready to challenge them to get now. But are they ready to bring both matters to court today so that we can go to court? But the answer is a definite no. They won't be able to do that. And I can guarantee you, in the next sitting, they will not have joined the two matters. This is the solution.
As please the court. Lordship, Mr. Mashangu is a senior attorney. I hope he understands how things work. Let me start by this, Lordship. My colleague alleges that the charges is true.
Really, if I may object, my colleague should then listen to what I said before he uses. I never said they were going to withdraw. So I said the next action is going to withdraw. The language that is said is a matter of fact, they were going to withdraw. Not that they have announced it. So you should not listen. I do not intend to stand up and as my colleague speaking, so I request that he actually make these submissions as a part of the system.
Here's a claim, Your Worship, it's not a train smash. We can leave the issues of matters being withdrawn or they will be withdrawn even if the court is not told what are the reasons. Let's deal with the matter per se. When the state says the investigations are complete, I expect that my colleague will understand that means that if the trial will have to start, the state will start with it. But that is not how it works. There are also other nitty-gritties which you have to go through before a trial starts, including if the matter is going to the High Court, there must be a drafting of indictment. after the indictment is concluded, a date have to be secured from the judge president. We cannot say today investigations are complete and then we proceed with them. That's not how it works. But be as it may, that is the decision, that is the internal matters of the DPP. With issues of centralization, it is common knowledge that centralizations are for purposes of convenience. We cannot be dealing with one accused in different courts every day. It can't. But when a matter is centralized, it is convenient for including the accused person, not only for the state. But be as it may, I can say it with certainty that the matter here, which we are dealing with here in this court, we are ready to proceed, but we need to be given an opportunity to draft a proper indictment. That is how it works. That is why the state is requesting a matter to be postponed for DPP decision, so that all the internal matters should be dealt with. In a matter which is at Kuruma, Your Worship, I can also say that the investigations are complete. I have discussed that with the investigating officer this year. The only matter which is left is for us to speak with the DPP on the other province, because we are not living in a banana approach. We have to do things procedure in a manner in which it is required in this country. So there's nothing new in centralization of matters. So it is for that reason that the state will request a remand to start with the process of centralization. Because it's not possible for the state to centralize the matter before the investigations are completed. So we required the investigating officer to first complete the investigation on the other side before centralization can take place. So it's for those reasons, Your Worship, the state requests a remand that proper procedures can be followed before the matter is transferred to them. That's all, unless the court wants to focus on a specific issue.
So I just want to establish the following. The centralization of the journey. I've heard that there's a common method that also is in this court, as the accused stands here, she's facing one charge of murder and two of fraud, and one of defeating the ends of justice. Which other counts are also going to be tried? Only from which jurisdiction?
They come from Kuruman. I'm not so sure which province is Kuruman. Not really Your Worship, but I can say with certainty that there is a count of murder. And there are at least more than 5 counts of fraud of similar nature as in this one.
From the civil courts? From whom?
Yes. That's what I'm certain of as of now.
When you say those cases are all investigations of
That's correct.
I just want to also establish is forced to be in making the necessary arrangements for centralization and ultimate developments, let's say, since 28 March, who was that? What was
Your Worship, before an indictment can be drafted, all investigations have to be completed. And if investigations are not completed, it's not possible to draft an indictment. And the Kurman matter, it's only recent that on that matter the investigations have been. So it was impossible for us to draft an indictment. Worship, the state will request at least a minimum of 2 months. If it was for only the issue of indictment in this, for the matter that we are currently in, it was going to be a simple matter. But it's not only this matter. We also have to do the centralizations, which requires the other provinces.
Also bear in mind that we are guided by the rules and standards as a as well as justice. And matters of this nature, seeing that it's matter which is not valuable in this court, but which ultimately has to be transferred to an island. We are guided by a 6 months period, which is already at the rules. 6 months also obviously. Is there no way in which you can fast track this process of centralization? Within that, Mr. Humanitarian also said earlier that you are from the police office. And you agree on that. It's the same office, just on a different part. Is there no way in which you can communicate and fast track the process?
Your Worship, we always do our best that matters should not be delayed. But matters depend on their nature, the complexity, and all that. So we will do what is reasonable possible on our powers to fast track them. I believe so, Your Worship.
That falls within the individual office.
You see, the state is language is banana republics, systems, and we speak as if these things are new in this country. These things have been there since time immemorial. As long as you have the criminal justice system, you have these systems. And when you get inducted into to become a state prosecutor, they are taught these things. Now, they are aware of the Chief Justice Directive with regards to the 6 months. They are quite aware of that. Now, what do you do to circumvent that process? What do you do to then circumvent those directives, those norms and standards? You create all these pockets of things that may create an impression that things are not what they're supposed to be or things are what they're supposed to be. They're asking for 2 months. When they could have set the borrowing, and my colleague misconstrues my submissions, and he responds to something that I never said. Context like this. I am saying, when they came to court and they refused bail, they said, the case in Setshwantsho is a slam dunk. And I'm saying to this court, the case in Setshwantsho, it's a done deal matter. The accused person is guilty. So it's just a question of formalities. And I'm saying to this court, that case will be withdrawn to the next appearance. It's on record in the case in Setshwantsho. The case in Kuruma, they are saying that the TPP has to do this, they have to draft indictments. Do they have a preliminary indictment? We should have then awaited the completion of the investigations so that they then now put in whatever would have been necessary, would have been occasioned by the further investigation or the finalization of these investigations. My colleague is speaking about the dates from the judges. I've made a submission from the judge president. I've made a submission to the Supreme Court that they have not taken this court into confidence to say that have they commenced with their request to the High Court Northwest. At least for them to be able to say, for them to be able to respond to your worship when your worship raises the issues of norms and standards. To say that your worship, in considering your norms and standards set out by the former Chief Justice of this country, we have already, even though that we cannot formally get communication that confirms the dates, communication that confirms this and the other, but we have started the conversation with the register to request the register to inform the judge president of our division that this matter is coming. So that when it does come ultimately, it is not the recreation of something, we're not starting something new. We are at least finalizing that which was already in the pipeline. Now, my colleague says that the point that he does not respond to is the fact that the issue of the joinder or the centralization of this matter is not new before this court today. It was submitted on the previous occasion in March already that the state intends to start that process. I would have expected in the minimum, not dictating how my colleague should prosecute his matters, to at least take this on record into his confidence and say, Your Worship, despite the fact that investigations are incomplete and we've requested Captain Mapunda to frustrate the investigations, we have, however, started conversations with our colleagues in the Northern Cape, so that once the investigations are completed, once the indictments have been finalized, it then becomes a foregone, it just becomes an issue of crossing the T's and crossing the I's that we get the matters into before the High Court. But they're not saying that. What they are saying is that they are not ready. My colleague can say all he wants about processes, and I'm familiar with those processes. I'm just saying that they are not taking this court into confidence to say that, having requested or having informed this court on the previous occasion that these matters are going to be centralized, what steps have they put in place? What measures are in place to ensure that when the day comes, because the day is here today, now they're going to start and do the processes. Now they're no longer working within the 6 months as set out by the former Chief Justice. Now they're going to start a new 2 months period. They're asking for 2 months. What they seem to forget is that Mrs. Setshwantsho is in custody. And it's convenient for them that she's in custody because it speaks to this picture that they want to portray in the public space. It feeds into this notion that they are pursuing in the public space. It feeds into this excitement that has been created around this matter. And I've made this submission in this court before, that we ought not get excited over such things to an extent that we forget to implement the laws that guide us, the laws that make us wear these black robes, the laws that make us stand here today and speak to you. We should never forget that and now invite external influences than to dictate our thought process. The state is yet to draft an indictment, an interim indictment. The state is yet to converse with the registrar of the Northwest Division. The state is yet to engage its counterparts in Guruma in the Northern Cape province, the DPP in the Northern Cape province. Now they want a further 2 months. If they had done these things when they left court in March of 2024, they'll be singing from a different hymn. So I request that the court must take into consideration the fact that Agnes Setshwantsho is in custody. Her life has essentially stopped because we've allowed the state the time and opportunity to conduct its investigations. We've allowed the state to make the decisions that they wanted to make in relation to the centralization of these matters. We've allowed the state to go and look for every other thing that she has done thoroughly when she was still in primary school, for them to then start piling on charges until we get to where they want to get to. So I'm saying, these delays are necessary. The request for postponement, especially the 2-month postponement, is unnecessary, it's unjustified, and is not deserved by the state. If the court is inclined to grant a remand, it should be the shortest remand ever. And this court ought not to be duped into these processes that, you still have to speak to the JP, you still have to speak to the registrar, you still have to speak to our police. That ought to have been started. The ball ought to have been started. The ball ought to have been brought from the 28th of March, I believe, when we were before this court. They ought to have at least started a conversation with our colleagues, with their colleagues in the non-compete. They ought to have done something. Something. They say that is a high-profile case, and I've said this in my media submissions. They claim that it's a high-profile case, but nothing about their conduct suggests high-profile. Nothing in their conduct suggests speedy and fair trial. Nothing in their conduct suggests that they're serious about this prosecution. Maybe Captain Magunda is serious, but I doubt that those that he reports to are serious about it. Thank you, Commissioner.
This court is not conducting an inquiry in terms of Section 342 of the Criminal Procedure Act as order. To that effect, the court, however, when considering the reasons advanced by both parties, also looking at the history background of this matter, that there is a delay. But when considering the fact placed before me by counsel for the state, the court concludes that at this stage, this court delay that is taken into consideration seriousness, basically, all the 3 of the charges that the accused is facing. I'm told that the investigations under all these circumstances are very complete. All that's left to be done, all happens, centralized, and I think I'm then transferred now to the relevant court. So bearing in mind responding to this matter to allow the state opportunity to get their consideration is justified for the reasons advanced. However, the court finds that period of time is too long and that it will impact also the accused lives with fears and petition for postponement is granted. Postponement is not reasonable, which is what finds its reasonable. The state feels issues. We may consider as much further
se mo tlogela sethapo sa gona nnyana ka bonkana fela morago ga go bua bosekisi le moeledi ya gago ka gore molato o busediwe ko morago gape la go sekiseng ke tse go tlhalosa gore dipatlisiso tsone di feleletse mo molatong o mme bone ba na le matsapa gore tshwanetse go kopanya melato le gore o latofetsa kwa yone go tswa ko kurumane ba ke ba etsenye nne se se le sengwe se gone ga go isa ko lekgotleng le letona la mo mamahikeng mme motlotlhegilene wa dumela gore e ka busediwa ko morago mme ga ba go khetse busile go mara go ka khitse pedi so sone ga se mo khatlhele ya go siamisi le ga se mo khatlhele ya gago ka go na le tshwana la gore khitse ya go e sekwe ka nako le gore ya utlwana le ne ke ile mo la ke Chief Justice mo go mera te yotlhe e le gore ya go sekwa go makgotla ba go dimo a ne ba kgwedi di le 6 gore di hele dilo ka dipatlisiso le di tsamaya molato o na le kgwedi di 6 le beke o ntse o sekwa go go dipatlisiso ga se di felle mme ke sa go fela e ka isiwa go morago mmaka kgwedi ga jana go sekisi mo go le mo ga go go sentse ba ya seka-sekana le ntlha mo le ya letlha gore ba ka ibusetsa go fitlhela le
Did I arrange worship is the 27th of June? That's correct.
The 27th of June is confirmed that the defense will then only set the date of the state on notice and it is
The next June, the notice based on
yes, sure. That's what this is. Bishop, may I take instructions?
yes.
Thank you, Bishop. Yes, Your Worship. It's merely housekeeping, it's merely humanitarian issues. The first thing is that Mrs. Setshwantsho was assaulted on Thursday last on the African Humanitarian Center. To an extent that she bled from her right ear. To date, she has not received medical attention. And I make this point simply because the medical officer who was here during the bail application confirmed to this court that she sees patients or the inmates on a regular basis. At least she's there in a week, no less than 3 times. The incident happened on Thursday was reported to the officials in the center, in the detention center, and nothing has been done. Now on Wednesday today, at least 7 days has passed, and she has also seen medical attention. I'm sure that should be placed on record. And the court should demand the state to behave in a manner expected of them fulfilling their responsibilities. But the transportation of the accused from Mafeking to Kuma and back to be done in the most humane manner possible. Does it make sense that you're going to refuse a diabetic an opportunity to eat? You're going to refuse a diabetic an opportunity to relieve herself, a comfort break? You're going to drive with a female diabetic detainee from Human to Mafeking non-stop without giving an opportunity. When you have in your escort a TRT, and you are unable to give a comfort, that is inhumane. The state does not persecute us. They should never wear the method of being persecutors. That is a very, very fine line. It's a very, very thin ice they are skating on. They do not want to test the defense in that regard. They'll be called out and they'll be found wanting. That when the investigating officer wants to make investigations at hospitals, clinics, he should not take the accused person. She's not part of his investigation. She's the subject of the investigation, but she's not part of his investigation. He should desist. And I'll request this court to put the state on the I'll make the same request to the woman magistrate, to your brother woman, I'll make the same request. But even though she's a detainee, she's not an animal. The state should desist from treating her like an animal. Number 3, she's not Rose Ellen. Rosemary somebody. Rosemary. The names are Setshwantsho, Agnes Segomotsi. Members of the SAPS, the investigating team, and anybody else involved in the investigation should desist from referring to her as Rosemary. That seeks to suggest one thing only. That the state has become biased in its investigation and conduct towards her. The state has decided to paint her in a brush of a convicted person, in the same brush as a convicted person, despite the fact that she has not been found guilty by the judicial court, and despite the fact that she has not stood trial. I would request the state that they have a duty. It's their job. They get paid on every 25th of every month to act humanely towards detainers. It's her constitutional rights. They must recognize them. They must protect them. If she's not a problem, if she's not acting, if she's not becoming a nuisance to them, if she becomes a nuisance, they must punish her accordingly. There are rules and regulations that she must comply with. As a corporate
ga ile go tlhoka go ema kgona go ithusa ko ntwaneng ba sa go kgaletsa tshwanela go o ile yalo botho ba bone bo tle bo nna go pele le dijo le gape go nno tlhasitse maloba mo kgolegelong ba seke ba go isa ko ngakeng gore o go thusiwa ile gore noopa mo tsebeng o tswa madi o na kopa ka kokobetso gore ba go tshware sentle o na le ditshwanelo hela yana ka bone ba ile mmereko wa bone ba gollang 25 tse tsa kgwedi ba tlogele go dira yalo le gore ba tlogele go bitsa Rosemary eo yona ba e kganela ka gore Rosemary ke mosadi e leng gore ga bona molato wena yaka o eme fa mma ga o se o bone molato ke lekgotla lepe kana lepe ba tlogele go dira yalo
I will the investigating officer is here. And as far as he informed me, he is treating her in a human manner. He is treated like any other inmate. One thing the accused must realize is that prison is not a 5-star hotel. As long as she's treated within the boundaries of human rights, that is normal. But don't expect things which are extraordinary, which are beyond the normal standards of living conditions in our normal life. That's what I can say.
Mafiking female detention secretary.
Application also.
May I take instructions? Thank you, Your Worship, for the indulgence. It's not a reply per se, but I'm taken aback by the submissions by my colleague. My colleague seems to insist on responding to what I was not saying. I never said my child expects to be treated with kids' stuffs. I never said that she should be treated as if she's in a 5-star hotel. All I said was that there were norms and standards, there were rules and regulations. If she does not comply, she must be punished accordingly. That's all I said. That when she is forced to relieve herself in the motor vehicle en route from Human to Mafikeng, now you tell me that this 5-star treatment to to any person. That is the custody government. If she's forced to relieve herself in a moving vehicle whilst in the company of male police officers. Now, I'm not asking for something extraordinary. I'm asking for the police to do their jobs. Hence, I use this word specifically. Do that which you are paid to do, everyone. Do not introduce things that you are not paid for. Because if we're to pull the rules and regulations of SAPS, the governing documents of SAPS, how to treat detainees, and we're to match them with how this Setshwantsho is treated, we will find holes, we will find the state quality. I do not want to get to that space. That's why I said the state is getting in eyes and it's beginning to test the defense. And once the defense is tested, I hope the state has its house in order. I know the mistake that I made, I did not converse with my colleague before I made this application because I thought somebody else was coming. I sent a message to the defendant prosecutor. The one that was here the previous time. I think it's application or I've spoken to I had not spoken to the current council, and that I should apologize to you because I thought somebody else was coming to court today. However, my submissions remain treat her as a prisoner, but treat her within the treaties and the statutes that South Africa has signed on how to treat detainees and arrested persons. That's all we are asking for. We're not asking for her to be taken to custody.
Has been all that until the decision, the decision, centralization of the charges, used to remain in custody. This is coded in terms of section 842A, being notice given by the Constitution. It's also ordered that the head of the female detention center for any one of his delegates may be accused to the facility to receive the portion.
Setshwantsho ke tla go buisela morago fitlhela lekgala le 27 June 2024 mo godimo ga moo lekgotla le ntshitse taelo go ya ko beng ba ba tshwereng ko tshwereng teng ko Maikeng gore ba go ise go bona ngaka morago o buisele morago gore bosekisi bogolo go go tsa tshwetso le gore ba kopanye melao nkama 27 June 2024. Dula.
Maybe let's choose the next
Alright, record, alright.
That's why you're taking out, okay?
15 minutes.
That's why